How would you feel to discover that YouTube now believes that in order for your videos, your content, to be protected from unauthorized re-uploads and have basic copyright protection, you have to actually register a copyright claim with the Copyright Office and possess a certificate of proof on every single individual video or upload you wish to protect. As if that copyright doesn't exist automatically, and if you don't own one to prove the video is yours, then it's fair game for anybody else to re-upload it. Doesn't that sound absurd and insane? Well, this is the stance they have taken with me when I reported one of my shorts, an animation that I created, re-uploaded without my permission. And I'm bewildered by their response. Hi all, my name is Art, and I wanted to share an experience I had with YouTube and also provide some very interesting information that may benefit a lot of content creators who are struggling with a particular issue. That issue being having your content stolen and re-uploaded without permission, i.e., copyright infringement. Now, I've been on both sides of this issue. I've had false copyright strikes on my videos, and it was one of the most terrible user experiences I ever had, finding all sorts of restrictions on my account, including the inability to even file a counterclaim against one of the strikes, because the system automatically decided I was abusing the counterclaim procedure, simply for attempting to file more than one counterclaim, seeing as 2 videos were struck, not one. And also not being able to speak to a single human being throughout the entire process, no matter what email I used or who I reached out to. It was horrendous. I thought to myself, maybe there's just a creator bias. Maybe they're so diligent about protecting creators and their content that they have all these super strict guardrail systems in place. Nope! Boy, was I wrong. Having now experienced the other end of this spectrum, I can tell you my experience has been just as insulting. So, what happened? Long story short, an individual I'll keep unnamed for now has been ripping my video uploads from my Facebook and YouTube pages and re-uploading them without permission, both to his YouTube and TikTok. I kindly asked him to remove them, even offering to negotiate a situation where I'd allow him to share them, but he refused to talk and just blocked me on every platform. This subsequently meant I had to report him for infringing content. I provided the original URLs to my content where it was stolen from. Many of the videos still have my personal watermark on them too. I gave them screenshots of the original files on my PC, which included their hard-coded creation dates in the metadata. And of course, I provided my signature and sworn testimony of ownership, etc., etc., essentially fulfilling all of the statutory requirements for a valid dmca takedown request. The response I received was nothing short of an interrogation, followed by a complete dismissal of my lawful claim and refusal to act upon it. More on that in a moment, as I'll share some screenshots of our conversation. Little do they know, I'm a law buff, and law has been a hobby of mine for over 20 years. So I went and did some digging. Now I must clarify, this is just my opinion, presented for educational and entertainment purposes, and is not to be considered legal advice. Do not take this legal information as gospel. Make up your own mind and always consult a trained legal professional. Moreover, I should further clarify that I am not making the claim that YouTube is breaking the law or treating others this way. I am merely asking the question as to whether they might be, and ultimately, that is for a court to decide. I am simply sharing my findings from the relevant legislation and my personal experience and opinion. With that said, here's some important info you may wish to consider if you ever find yourself faced with the same abhorrent and arrogant, tyrannical overreaching from YouTube, when you're simply seeking the most basic protections afforded to you under the law. Here is the first response I received.
Thank you for your removal request. We've reviewed your request and need some more information from you before we can proceed. Please read the entire email carefully for a complete update of each video's status. For each video listed below, give precise identification of the particular copyrighted work allegedly infringed and the basis for asserting the claim.
I didn't quite understand the question. I provided all the evidence, and I made my legal claim to ownership under penalty of perjury. So what exactly are they asking me for here? My basis should be obvious. So I told them, I'm sorry, I don't quite understand what you're asking me. The entire video is mine. I created it, I drew it, I directed it, I edited it, I wrote the script, the dialogue, everything. The content as a whole has been ripped in its entirety and re-uploaded without my permission. The entire short is a vision that's come straight out of my mind and into visual medium through my efforts alone. I even have the original file on my PC. That video is the product of my time, my money, my labor, and my creativity. Nobody has the right to steal it and pass it off as their own. I was the sole individual responsible for all aspects of its creation process. That is my basis. Their response was as follows.
Based on the information you provided, it is unclear how the work specified for the video listed below is protected by copyright. For this reason, we are unable to process your request. To help us evaluate your request, you may wish to explain how you created the work, describing the process you followed and the tools you used. Other supporting documentation, such as a copyright registration certificate that is issued by competent authority, will also be helpful.
We'll hear more from YouTube in just a moment, so bear with me. This is where the problems begin to arise. If you're a content creator, you may be interested in this, so listen carefully. According to my recent correspondence with them, it appears YouTube now believes that they have a right to demand that you present to them a registered copyright certificate from a competent authoritative body in order to comply with a dmca takedown request. In other words, unless you pay for a copyright registration on every single video you upload, it's fair game if anybody wants to steal it and re-upload without your permission, because they will not act or remove it otherwise. Does that seem fair or reasonable? I don't think so. Does that seem lawful? Let's examine the law and find out. For context, US and UK copyright law don't acknowledge such an absurd requirement, and a service provider has no right to make such extra legal demands as a basis for complying with dmca. And to expect content creators to be registering all of their individual content uploads just to be afforded the most basic of copyright protections is utterly ridiculous. Under basic copyright law, copyright exists and subsists automatically in original works, and registration is optional. Imagine having to pay for a certificate for every single video, or music track, or poem, or thing you create and publish. That's simply not how things work, as we'll see shortly. I'll give you a bit of insight for anybody else who may be struggling with copyright issues as a creator. The reason companies that provide hosting services have indemnity against those kinds of claims and can't be sued for copyright infringement is, first and foremost, because it ought to be considered unrealistic for them to be liable for such mass content management, with user uploads being out of their control for the most part and in quantities difficult to moderate. Nevertheless, they still have a duty to be somewhat accountable for that. So the compromise they created was called the Safe Harbor Rule. 17 U.S.C. Section 512, known as the Online Copyright Infringement Liability Limitation Act, OCILA, is a provision of the Digital Millennium Copyright Act, DMCA, enacted in 1998 that establishes safe harbor protections for online service providers, OSPs, from copyright infringement liability, but only under certain conditions. For service providers storing user-generated content, The safe harbor applies if the provider does not have actual knowledge of infringing activity, is not aware of facts making infringing activity apparent, and acts expeditiously to remove or disable access to material upon notification. Note, the term expeditiously here is generally interpreted to mean 48 to 72 hours by any reasonable standard. Under this statute, a legitimate dmca takedown notice is valid when only the following requirements are present: a physical or electronic signature, identification of the copyrighted work, identification of the infringing material, contact information, a statement of good faith belief that the use is unauthorized, and a statement under penalty of perjury that the information is accurate. That's all. Nowhere are you expected to register for certificates. Nowhere are you expected to divulge your creative processes or give any further evidence the work is your own. These providers are not courts. They should not be interrogating you, making extra legal demands, nor trying to arbitrate any kind of truth or be demanding evidence outside of what is required by law. The provider's duty under Section 512C is described as the moment a provider receives a notice that satisfies Section 512C3, it must act expeditiously to remove or disable access to the material. It does not get to demand evidence, weigh credibility, or investigate authorship. The only question it may ask is whether the notice meets the 6 formal elements: identification of work, infringing URL, etc. If those boxes are ticked, the platform must remove the content and then notify the uploader. The logic is simple. Notice first, argue later. The counter-notice process under Section 512G is described as if the uploader believes the takedown was mistaken or abusive, they can submit a counter-notification, again under penalty of perjury. At that point, the platform can restore the material only if the complainant does not file a court action within 10 to 14 business days. This creates a symmetrical system of sworn statements, leaving questions of truth or ownership for the courts, not the host. This, in my opinion, is actually a well-formulated and effective system, when it's actually complied with, that is. What we as content creators do not need are the service providers, such as YouTube, playing judiciary and messing with our livelihoods simply because they want to play judge, jury, and executioner. We cannot and should not abide by such power-tripping narcissism. Behavior like this, acting outside of the law, if left unchecked and not curbed immediately, runs the risk of becoming a precedent for that continued company misconduct and a dangerous slippery slope that could hinder and damage many creators. By demanding proof, such as a registration certificate, or interrogating your creative process, YouTube is 1. Moving from a neutral conduit to an adjudicator, which the DMCA never authorizes. 2. Altering the statutory balance, since you already made a perjury-backed declaration. 3. Risking loss of safe harbor, because refusal to remove after valid notice equals actual knowledge of infringement. The U.S. Copyright Office, USCO, explains that online service providers earn the protections of the DMCA's safe harbor only if they comply with the notice and takedown framework. A valid notice must contain the statutory elements in Section 512C3, after which the provider must act expeditiously to remove or disable access to the infringing material. In Capitol Records LLC versus Vimeo LLC, 2013, the Second Circuit reaffirmed that the safe harbor defense under 17 U.S.C. Section 512C is available only if the service provider lacks actual or red flag knowledge of infringement and acts promptly when notice is given. Together, the USCO guidelines and the Capitol Records decision underscore that a provider's protection is conditional. Once valid notice is received, unwillingness or delay in removal places the provider at risk of losing the safe harbor shield. It is my opinion then that a provider is not required to, and indeed should not, undertake its own investigation into the merits of a takedown notice. Its job is to follow the DMCA procedure, not to play detective. Copyright registration in the United States is governed by 17 U.S.C. Section 408 to Section 412. It is optional, not a condition for protection. As the statute explicitly declares, registration is not a condition of copyright protection. 17 U.S.C. Section 408A. Registration merely provides procedural advantages if you later sue for damages. It is not required to assert ownership or to issue DMCA notices. Every distinct work is independently protected upon creation, but if you seek the procedural benefits of registration, each one must be filed separately unless they qualify as a collective work. Thus, if YouTube's logic were to hold, they would be expecting every content creator, every vlogger, musician, animator, and meme poster to register each individual upload with the U.S. Copyright Office before being eligible for takedown protection. That is patently untenable and directly contrary to the entire legislative intent of the DMCA, which was designed to protect ordinary online creators. Even on YouTube's own public pages on copyright policy, it states, creators should only upload videos that they have made or that they're authorized to use. That means that they should not upload videos that they didn't make, or use content in their videos that someone else owns the copyright to, such as music tracks, snippets of copyrighted programs, or videos made by other users without necessary authorizations. Moreover, according to YouTube's help page, submit a copyright removal request. Rights holders may submit a request when your copyrighted content is on YouTube without your permission. The page provides no requirement for the claimant to hold a registration certificate. Even though YouTube's own policy language may not explicitly state the registration point, their help page does allow submission of removal requests without requiring registration details, and they do not list registration certificate as a mandatory requirement. With all this in mind, here is the formal response I issued them. I recommend those who might be in a similar position not to copy this notice verbatim, but by all means, feel free to use it as a guideline template to create your own. I am now formally responding to your request for clarification regarding my DMCA takedown notice. I confirm the following. Authorship and ownership. The video in question is an original audiovisual work created entirely by me. I was solely responsible for every element, including the writing, directing, editing, artwork, and audio. No other person was involved in its creation or has rights to this work. Identification of copyrighted work. The copyrighted work is the video as a whole, the original short film uploaded by me. It was first published by me on Facebook on the 4th of October at 11:59, seen here, inserted URL, and then later subsequently uploaded to my YouTube and DeviantArt and other platforms where I host my content. Infringing material. The infringing video uploaded by redacted name is a direct, unauthorized re-upload of my work in its entirety. It reproduces my copyrighted video without modification or permission. Supporting evidence has already been provided, which includes links to the original uploaded content across my multiple accounts and platforms, YouTube, Facebook, DeviantArt, etc. I also hold the original source file on my own computer. Attached is a screenshot of that. Legal declaration: I have a good faith belief that the use of the material described above is not authorized by me, an agent, or the law. I swear, under penalty of perjury, that the information in this notice is accurate and that I am the copyright owner. Accordingly, I respectfully insist that YouTube act in compliance with 17 U.S.C. Section 512C1C, and remove or disable access to the infringing video expeditiously, as required by law. If you require anything further that is directly relevant under the DMCA, please specify clearly. However, please note, the statute does not require me to divulge creative processes or hold a registration certificate. Copyright subsists automatically in my original work. Sincerely, name, email, phone number, date. Now you would think, after the law had been laid out so concisely for them, and their duties and obligations made so clear and unequivocal, the dust would settle, and they would realize they couldn't pull the wool over my eyes and take advantage of my supposed ignorance, and therefore would simply comply with the law, rather than risk the penalties of breaking it. Unfortunately, no. They chose to double down. Here is the response I received.
Thank you for your response. We've reviewed it and provided updates below. Request declined. We remain concerned that your copyright notification is not valid for the video listed below. To confirm the validity of your request, we require copyright registration certificate issued by a competent authority. As a result, the content will remain live on YouTube until you provide the requested information.
So, what happens if a company fails to comply with the law, specifically 17 U.S.C. Section 512C1C, and does not remove the infringing content expeditiously when having knowledge of that infringement and in lieu of a lawful counterclaim? Or if they refuse on the basis of you not providing information they had no legal authority to require? Well, it's not just the infringing party who stole your content that becomes liable. Guess who becomes liable now? Correct, it's the service provider. Because non-compliance with DMCA standards waivers or forfeits their safe harbor protections under that act. So now they can be sued directly. You can potentially, if they continue with their non-compliance, file formal complaints with the U.S. Copyright Office's DMCA Agent Registry and the UK Intellectual Property Office, IPO, and notify the Information Commissioner's Office, ICO. Moreover, you may choose to lodge a civil claim for damages resulting from negligent facilitation of infringement, as permitted under 17 U.S.C. Section 512J and the UK Copyright, Designs and Patents Act 1988. You may have guessed by the info in the video so far that I live in the UK. Obviously, if you're in a different country, your recourse may be slightly different, and you should alter your approach accordingly. Oh, how far we have fallen, that companies have become this corrupt and overreaching, and that you would have to jump through so many of those hoops just to be afforded the most basic of rights and protections. Do you think this is an injustice? Comment below and let me know your thoughts. My final response to them was as follows. Dear YouTube Legal Department, I refer to your recent correspondence declining my DMCA takedown request on the basis that I have not supplied a copyright registration certificate. Please be advised that this demand is extra-legal and inconsistent with 17 U.S.C. Section 512C3, which sets forth the exclusive statutory requirements for a valid notice. Nowhere does the DMCA authorize a service provider to refuse compliance on the basis that a work is unregistered or that a certificate is not provided. I have already fulfilled all statutory elements: identification of the copyrighted work and infringing content, sworn statement under penalty of perjury, and electronic signature. Your continued refusal to remove the infringing video therefore constitutes a failure to act expeditiously as required by Section 512C1C. Consequently, YouTube and Google LLC now hold actual knowledge of infringement and risk forfeiture of safe harbor immunity. You are hereby granted 48 hours from receipt of this message to comply by removing or disabling access to the infringing material, or I shall 1. File formal complaints with the U.S. Copyright Office, dmca Agent Registry, and UK Intellectual Property Office, IPO. 2. Notify the Information Commissioner's Office, ICO, for negligence in rights holder handling. And 3. Prepare civil proceedings for negligent facilitation of infringement under both U.S. and UK copyright law. This notice is sent in good faith, but I will not hesitate to escalate through appropriate legal channels if compliance is not achieved within the time frame stated. Yours faithfully. Please, if you would be so kind as to spread awareness of this problem before it becomes too big. We cannot allow big tech to take advantage of creators like this. YouTube drama and controversy like this can pull in some pretty good numbers, by the way. Something to consider if you're a creator. If anybody out there would like to create some content about this issue or this experience of mine, feel completely free to use my words, my images and correspondence, or anything I've presented here. Use it, rip it, remix it. Do what you must. My only request is that you don't simply re-upload this entire video in whole, as it is my personal testimony and took quite some time to create. But please share it or leave a link if you'd rather do that than add your own commentary. In closing, if you just sat through the whole video and ground your teeth through this god-awful AI-generated voice spouting legalese at you, thanks. You're one of the real ones. And please forgive me for not wanting to publish my actual voice online at this point in time due to privacy concerns. Fight the power, stick it to the man, and let's take back this platform. This is our tube, not theirs.